Ladies and gentlemen, I'm Robert W. Matanke, president of the Decalogue Foundation and a past president of the Decalogue Society of Lawyers, the Jewish Bar Association founded in Chicago in 1934. Welcome to our presentation on protecting Jews on campus. Today's program is sponsored by the Decalogue Foundation and the Decalogue Society of Lawyers and co-sponsored by the American Association of Jewish Lawyers and Jurists, the Louis D. Brandeis Center, Stand With Us, and DePaul University College of Law Center for Jewish Law and Judaic Studies. We encourage you to support each of these organizations so that we can all continue to provide legal and educational programming, support the law and Jewish students, and stand with the State of Israel. I will introduce each of our three panelists, and following their presentations, I will moderate the question and answer session. During the presentations, you can enter your questions into the chat box so that they can be posed to our panelists during the question and answer session. For those attorneys who have registered to receive mandatory continuing legal education credits, please make sure that you complete the evaluation form at the end of this seminar. Certificates of attendance for CLE credit will be emailed within the next few weeks. As a past chairman of the Hillels of Illinois, I receive regular reports about civil rights complaints filed with the U.S. Department of Education against the University of Illinois in Urbana-Champaign, which was recently settled, and the recently filed cases against Northwestern University and the School of the Art Institute of Chicago. These actions have been and are being pursued by the Jewish United Fund of Metropolitan Chicago, the Hillels of Illinois, and Hillel International with the assistance of Ken Marcus and Eliza Lewin of the Louis D. Brandeis Center for Human Rights under law, and Steve Blonder, who succeeded me as chairman of the Hillels of Illinois. It is now my privilege to introduce Steve Blonder. Steve is a partner and member of the management committee at Much Law. He focuses on complex business litigation and has argued successfully before federal and state appellate courts across the country, as well as the Illinois Supreme Court. He leads the firm's social responsibility initiative, Much Community, and encourages his colleagues to support nonprofit groups, dedicate time to pro bono work, and volunteer for important causes outside of the office. Steve earned his bachelor's degree with distinction and honors from the University of Michigan in 1990 and is a 1993 graduate from the University of Chicago Law School. Steve Blonder has been dedicated to pro bono and community service work throughout his legal career. He received the 2012 Award for Excellence in Pro Bono Service from the United States District Court of the Northern District of Illinois for his work on the Mezuzah case, which went all the way up to the Seventh Circuit Court of Appeals. In 2023, he received the Public Service Award from the Chicago Bar Foundation for his pro bono work and for serving as chairman of the board of the directors of the ARC, which provides Jews in metropolitan Chicago with free, life-changing human services, and which last year completed a nearly $24 million fundraising campaign to renovate and significantly expand the headquarters facility for this institution. Steve has also served in leadership roles on many other nonprofit boards over the years, including the boards of the Decalogue Society of Lawyers and the Jewish Federation of Metropolitan Chicago. And now I ask you to join me in welcoming Steve Blonder as he addresses the topic entitled Filed, Pending, Settled, How Title VI Cases Are Battling Anti-Semitism on Campus.
Thanks,
Steve,
Bobby.
it's all yours.
Thanks,
You're
Bobby.
welcome.
Although with that introduction, only needed one line actually, and that is Steve has spent a significant part of the last year litigating anti-Semitism issues kind of in federal and state courts in Chicago and consulting with organizations behind the scenes on campuses throughout the country. I will freely admit before some point last year, I never thought I would have an anti-Semitism practice as what almost became for a while a full-time practice. But it is a reflection of the times that we live and where we're at in terms of issues that we've got to deal with. So I'm going to start off and I want to just give an overview on a couple of things and kind of set the stage for what David and Eliza are going to talk about later as well. Litigation. So most people think of litigation and run for the hills. That is, except for unless you're a lawyer who's actually doing the litigation to try and change the law or change a policy. With anti-Semitism on campus, litigation has become a strategy and a tactic to try to make a difference. So let's talk about what that means. In 2019, Title VI was expanded to include anti-Semitic acts. That was, again, until 2019, it really didn't cover anti-Semitic acts because it was limited to race, national origin, gender. So that was kind of a sea shift. Title VI prohibits discrimination on behalf of anyone who receives federal funding against someone based on their being in a protected class. That's kind of, if you strip out the legalities, that's what it says in plain English. And if you have a complaint, so let's talk about universities, it goes one of two directions. You can either make a complaint with the Office of Civil Rights of the Department of Education, which will then investigate, look at it, review it, and potentially sanction a university that receives federal funding. It can go so far as to recommend the termination of that federal funding. Or you can go to the court system. So let's talk about both for a second. One of the issues with going to court is you need a plaintiff. You need a student, most likely, to stand up and put their name on a complaint that gets filed in the court of law, which becomes a public stain on their record. I can tell you, litigating these cases, it is darn near impossible to find a student who is willing to put their name on a complaint. And think about it. Like, I've got a kid in college. If someone came to me and said, Steve, would you put Matthew's name on a complaint that you were going to file against the university where he's at, alleging that they were engaging in anti-Semitic comment, I would say, hell no. Notwithstanding believing what's happening, believing in the issue, but I would say no. The same way many parents would say to their children, you can raise issues, you should complain, you should stand up, but don't put your name on a lawsuit. You can file a lawsuit under Jane Doe, but what I'll tell you the universities do, having litigated against them, the first thing they do is they say, tell us who your student is, because we want to verify whether or not they're actually a student, and we want to look into their records to see who and what they are and what they're involved in and what they've done. So that's kind of an issue that leads many people to take the path of going to the Office of Civil Rights of the Department of Education and filing a claim. That's, for example, what the Brandeis Institute and JUF did together at the University of Illinois in Urbana-Champaign, where they brought a claim to the Office of Civil Rights, which investigated and pursued the matter and resulted in a settlement earlier this year. The one advantage of going to the Office of Civil Rights is the students don't have to be publicly named because it's a private proceeding when you go to the Office of Civil Rights. So it's a way to protect the identity of a student. It can also be done organizationally. The issues are the same. Is the institution that receives federal funding discriminating against Jews? So let's talk about the University of Illinois for a second. That was a remarkable settlement. It followed 4 years of kind of fighting and kind of going around and around to get to that point. But what that settlement did was it embraced the concept of Zionism and Jewish students being protected. And that was kind of under the students' policy, under the school's policy, all of a sudden that became protected behavior. I mean, in addition to they were going to do reporting and do various other things. But what's different here is that you have a definition of anti-Semitism, which includes anti-Zionism, that's being embraced as part of the university policies and what's going to be enforced. So now, for example, standing outside of Hillel, standing outside of a Jewish fraternity and making an anti-Zionist comment is a violation of the university's policy. So when you think about it, about what that accomplishes in terms of safety for Jewish students on campus. So that was a remarkable outcome that really changed the landscape in Illinois and was the first of the settlements to do that. And it's actually one of the first examples of a university adopting that as part of its policies. In recent months, actually in the last month, you've seen the Department of Education, the OCR, have a number of settlements with universities. There was one with the California system. There was one, a school district in Pennsylvania, Rutgers, Occidental College, Muhlenberg College. There's kind of a range of these settlements. Most of them are fairly nondescript. they say that the universities will look into anti-Semitism, they'll kind of do a better job investigating things like that, but they're really somewhat toothless. Indeed, if you go back over the last 60 years or since the Civil Rights Act of 1964 was put in place, there's not a single university or school that has lost its federal funding as a result of Title VI violations. So just when you think about that, it's a threat, it's a hammer, it's kind of out there, but it hasn't actually happened anywhere in terms of universities. So just something to keep in mind. The OCR process is somewhat of a secretive process. You can't really control it, if you will, because the government can proceed at its own pace in terms of doing the investigation. And there are some that think it's a great strategy, others that think it's less than a great strategy because of that loss of control, the lack of publicity, etc. But it is a path to go. The second path is heading to the court system. Now, just so you know, if the student or someone makes a complaint to the Office of Civil Rights and then they go to the court system, the Office of Civil Rights will stop investigating that complaint. You can't proceed on the same complaint in two parallel places. It's kind of a one or the other. So just so you know that. And just the other dynamic is, particularly with respect to the court system, the cases have grown out of the encampments that we saw last spring. That's kind of really, when you look at the lawsuits as to what's been the impetus to several of them, leave the School of the Art Institute case that we filed to the side, and I'll talk about that because that's a separate case and a separate issue, but it's really kind of grew out of the encampments. However, as we all know, the anti-Semitism, what was happening on campuses, predated that. That was simply kind of something that happened last spring that was kind of a culmination, and it was a spark plug that led to lawsuits, but it predated it. So you have these encampment related lawsuits, and you have them tied to the anti-Semitism. Most of the lawsuits bring in the encampment, and then they go back before that as well to bring in the anti-Semitism that happened previously. Lawsuits have been filed, and they've gotten a lot of media attention. Harvard, MIT, Northwestern, NYU, Columbia, UCLA, kind of Rutgers, you have big schools, small schools, state schools, private schools. Again, any of them can be a defendant. The only concept is they have to have received federal funding. That's kind of where the issue is with it. Okay. So School of the Art Institute, I want to talk about that case for a couple minutes, just because it's a little bit different. We sued the School of the Art Institute a little over a year ago on behalf of an Israeli student, Jewish and Israeli, she first was denied admission. During the admissions process, as opposed to going through the normal process, they asked her specifically about her Israel experience, her experience in the army, things like that, as opposed to asking her about art and the art portfolio that she had put together. The school reversed course after a claim was made against them. Stand With Us helped her vis-a-vis her admission to the school. The school, after it was denied, the school flip-flopped and then admitted her. After October 7th, there were Palestinian students in the graduate program she was in who refused to collaborate with her, refused to engage in projects with her. Part of this was peer review, and you can imagine the scathing reviews that they gave of her as opposed to other students. But what compounded it was a teacher changed the exam. And what the teacher did, among other things, was used images, and this was after the final exam project had already been disseminated to the students. She imparted images of Israeli soldiers and Palestinians that, let's just say, were not flattering to those who are Jewish, and then changed the grading of that final exam when there was one student in the class who was affected by it. And that was our client, the Israeli who was in the class. School was engaging in an investigation, I use that in quotes, which was supposed to be done within 30 days. And I will tell you, 120 days later, hadn't been completed. The school made no accommodations for the student and basically had her in the cohort where the students were antagonistic towards her. The faculty members were putting her in situations for discussions that were inappropriate without regard to her safety. And the School of the Art Institute had a history of some issues, so it wasn't like this was a flash in the pan. We filed a lawsuit in federal court, and what was key about that was we were targeting her being Israeli and being targeted because she was Israeli. It was filed on an individual basis as opposed to on a class-wide basis, and we were alleging both direct and indirect discrimination. The difference there being on direct discrimination, saying the school had knowledge and acted against her based on her Israeli heritage, as opposed to being deliberately indifferent, which is the two ways that you can kind of assert an intentional discrimination claim here in this context. And I'll talk about what that means more later on. Just in terms of status, in that case, of course, the school moved to dismiss. That motion to dismiss has been pending right now for, I don't know, 9 months or so. Theoretically, a judge will rule on it at some point, but that kind of case was out there. It was the first of the cases that was filed alleging discrimination after October 7th. Now let me talk about the other kind of line of cases that's out there. And these are the cases that largely grew out of the encampments, and they were still Title VI claims. Most of the cases were involving a couple different theories. One is violations of Title VI, saying that the schools received federal funding and were discriminating or being deliberately indifferent towards the Jewish students on campus. The exception to that is the UCLA case, which has received a lot of publicity, where a preliminary injunction was granted. That case grew out of the encampment and was, because UCLA is a public university, was focused on free speech and the First Amendment issue, and saying that Jewish students were being precluded from accessing the parts of campus where the encampment was. So they're being denied, if you will, access to the campus itself and to the educational opportunities. The federal court in California granted a preliminary injunction based on those First Amendment grounds. So that case is it's a little bit different than the other cases out there because it is focused on the First Amendment ground as opposed to the Title VI discrimination ground. There are also Title VI allegations in there, but it's the First Amendment aspect that's received the most attention. The rest of the cases basically proceed along the following lines. They allege Title VI discrimination. They also generally allege a breach of contract claim. And what that claim says is under various state laws, the universities have these policies and procedures, and they make statements and promises to students to come. It may be you're going to have a safe environment. It's going to be someplace where everyone can learn. You can you look for the platitudes in either their handbooks or in their websites and their promotional materials. And the argument is that's a contract with the student. The student agreed to come with certain expectations that the university agreed to provide. And the university breached that vis-a-vis the discrimination, the environment, what happens on campus. These cases largely grew out of the COVID era, where students would make claims once they had to go remote, saying, hey, there were promises of a beautiful campus or things like that that create a contract. And there was some law that actually suggested you could proceed on a contract claim in that way. So that's kind of where the law comes out to support those types of claims. One thing that you should be focused on is a handbook policy or the platitudes can create an enforceable contract, but the promise needs to go above and beyond what is given under federal law, above and beyond what the federal rights are. There's got to be something more specific than that. And so one of the arguments tends to be allegations are made of college will be an inclusive space where everyone is respected or everyone is safe. It's statements like that that generally form the basis of a contract. There really haven't been any decisions yet in terms of the validity of these theories. You've had motions to dismiss at Harvard and MIT that were kind of ruled on and they kind of split decisions, but the law's still in its infancy in terms of these claims. So let's talk a little bit about the Title VI claims, which is kind of the more sexy claim and the claim that people want to talk about a little bit. So I said, it was only in 2019 that Title VI was expanded in terms of its application to anti-Semitism. And under these claims, the issue of, silence that. The issue of federal funding is not usually an issue. Colleges, public or private, are receiving federal funding in a variety of ways, whether it's through grants, whether it's through direct aid or other things. That's the easy part. The hard part is, how do you show deliberate indifference? Because in most cases, you can't show direct discrimination. So you're going along the path of deliberate indifference. It's a high standard. It's difficult to show. And the universities always respond with a motion to dismiss saying, well, we responded. We commenced an investigation. We did these kinds of sanctions to students, although often it's lip service and there hasn't been any real discipline. But that's really where the analysis is. So, for example, if you look at the Harvard case and the motion to dismiss, and there's actually two Harvard cases that were consolidated together, there they said Harvard gave lip service to the idea of any discipline and says the school says, well, we took these steps. We did A, we did B, we did C. And the school says, yeah, but steps were taken, but nothing actually happened. So the analysis goes beyond the kind of school's position, which is usually, hey, here's what we did. We tried, we did something. Northwestern, for example, points to, we made the agreement to take down the encampment. And they trumpet that as a positive, whereas everyone in the Jewish community looks at that as a negative and kind of saying they kowtowed, they gave in, they agreed to do these things, which then in and of themselves discriminate against Jewish students. And then at Northwestern particularly, the argument was they didn't even enforce the new policy they said they were putting in place, and they let it go. So the key here is this deliberate indifference. If you look at the MIT case and the Harvard case, which are two places we have some decisions, it really focuses on the discipline that's imposed on students. Is it real or not? And the legal question that's really framed is just initiating an investigation enough? Kind of what's the standard? Kind of what did the university actually do? They need to have taken some real action. So again, we don't have a lot of guidance because we don't have a lot of decisions yet on this, but that's where the fight is going to be on the deliberate indifference cases. In terms of congressional testimony, which factors in here, and I want to talk about that for a second, because, for example, President Schill at Northwestern testified before Congress, and what he said there was something to the effect of, they knew that it was an unsafe environment for Jewish students. I'm paraphrasing kind of what he said there. So the issue is taking what happens in the congressional testimony and then using that to support claims in the litigation arena based on the back and forth that the university presidents have with Congress. One of the issues, so for example, Northwestern, the school has to know of the harassment. They have to know of the discrimination. It's not enough to say, well, they didn't know about it, because one of the universities often says, oh, we didn't know. It was student to student or something else, and no one ever brought it to our attention. So this is an example where President Schill's testimony actually hurts Northwestern with respect to that. The other route, if you don't show deliberate indifference, is showing a direct claim of discrimination. And what that means is taking a comparator and saying, for example, and would be an example on campus. If the university enforces its policies with respect to Black students or LGBTQ plus students in one way, but enforces it different when it's an anti-Jewish thing, there's your comparator. And you say, hold on, the school's directly discriminating because they're treating Jewish students different than other students in a protected class. At Northwestern, for example, there were stickers on campus that say it's okay to be white. Now, the school acted because everyone knew that was a dog whistle for the far right. and it was a dog whistle for kind of anti-Black and anti-other activity. But yet, when it came to the same conduct vis-a-vis Jewish students or Zionists, there was nothing, from Northwestern. So the argument was that's a comparator, so you can make out a claim of direct discrimination. The direct discrimination claims are difficult to bring because the question is, how do you really find the comparator? And what's the example of where the university acted one way and acted differently the other way? So that's kind of, sorry if I was talking fast, but Bobby, there's my 20 minutes, which is what you gave me, to kind of give the overview of kind of what's going on in terms of litigation. Again, we're at the precipice of it. We don't have a lot of decisions yet, and it'll be interesting to see how it emerges. And I'm happy to answer questions. Bobby, you want to do it at the end, I assume?
Yeah, we're going to do it all at the end.
Okay. Happy to answer any questions in terms of what people have. So thank you.
Thank you, Steve, for a wonderful presentation and for all that you've done and continue to do on behalf of the Jewish people.
Thanks, Bobby.
And I didn't use the format for the introduction you suggested I should.
Well, you took the one that my mother would have wanted you to give, so that's fine.
You got it. Exactly. It's now my privilege to introduce David H. Levitt. David Levitt has practiced law at Hinshaw and Culbertson since graduation from Loyola Law School and admission to the bar in Illinois in 1979. A past president of Illinois Defense Council, he changed his practice to intellectual property law when he earned his LLM in intellectual property from the John Marshall Law School in 2000. Later serving as chair of DRI's Intellectual Property Committee and founder of Hinshaw's IP practice. Dave Levitt is co-chair of the advisory board of the DePaul Law School Center for Jewish Law and Judaic Studies, and is also one of the most active pro bono lawyers for Stand With Us. He has published more than 40 articles in the Times of Israel blog on topics including international law as applied to the law of armed conflict and international humanitarian law, proceedings against Israel in the International Criminal Court and the International Court of Justice, defining hate speech and its lack of protection under the First Amendment, dueling definitions of anti-Semitism, and Israel's international borders, and misuse of the word occupation under international law. And now I ask you to join me in welcoming David Levitt as he addresses the topic of responding to the university's First Amendment excuse.
Hello, everyone. Hopefully the screen is sharing correctly this time. I've had issues with this over time. And here is, so let's start with this. All of you are probably very familiar with the university president's testimony in December of 2023. These are quotes from that testimony. Congresswoman Stefanik asked at MIT, does calling for genocide of Jews violate MIT's code of conduct? That's a relatively, whatever else you think of her politics or her ambassadorship to the UN, which I think is her next potential post, if confirmed, that was a softball question. And here is President Kornbluth's response if targeted at individuals. At Penn, does calling for genocide of Jews violate Penn's rules of conduct? If the speech turns into conduct, not just the speech, it has to turn into conduct. And it has to be directed at individuals. It has to be directed and severe and pervasive. Then it is harassment. And it's a context-dependent decision. President Gay of Harvard, it can be depending on the context, and it has to be targeted at an individual. That was the answer. That was what most of the hue and cry was about. That's what cost at least two of these university presidents their jobs. So, does context matter? That was part of the discussion. Well, the International Holocaust Remembrance Alliance working definition of anti-Semitism, in fact, requires context. The contemporary examples of anti-Semitism include certain examples and certain situations, double standards, etc., taking into account the overall context. So yes, context matters, but in the situation that those speakers were being asked about, those witnesses are being asked about, those university presidents, the context didn't matter. And that's the point. What was going on campus is hate speech. And hate speech is not and has never been protected by the First Amendment. There are myths about hate speech. First, that it's too hard to define, that it is protected by the First Amendment, and that we cannot enforce the statutes or restrictions on hate speech. What is hate speech? Here's the United Nations definition. It's rather long, but I want to highlight a couple things. The term hate speech is understood as any kind of communication, speech, or behavior, it doesn't have to be just conduct, that attacks or uses pejorative or discriminatory language to a person or a group, not just an individual, based upon who they are, including ethnicity, nationality, religion, etc. And there's an important piece to this, that rather than prohibiting hate speech as such, international law prohibits incitement to what? Discrimination, hostility, and violence. What's important to note here is that it's not limited to just violence, and we'll see why that matters as we move through this presentation. It includes incitement to intolerance and hatred, and a triggering of discrimination, not just incitement. That's the United Nations definition of hate speech. This definition, from an article by Professor Parekh in 2012, cited in a 2019 article, to me is a three-factor test, which is the best and most succinct definition of hate speech. First, it is directed against an easily identifiable individual or, and again, we come back to the university testimony about individuals, a group of individuals based upon an irrelevant feature. Second, it stigmatizes that target group, whoever that might be. In this case, we're talking about anti-Semitism, so we're talking about Jews or Zionists, by implicitly ascribing to them qualities widely regarded as undesirable, something that we've seen in terms of anti-Semitism morphing, as you've probably seen other speakers. My favorite is a 3-minute video of Yossi Klein Halevi, which he talks about how Israel has become the nation, the Jew of the nations is the nation of the Jews. Exactly what's going on. Whatever is the undesirable quality at a given moment in history, that is ascribed to Israel and now to Jews and now to Israel. And third, the target group is therefore made as undesirable presence and a legitimate object of hostility. That is a very easy to understand and well-reasoned three-factor test determining whether something qualifies as hate speech. And as to anti-Semitism, I think that if you were to use that three-part test to the IHRA working definition, you would see that it meets both the Parekh and the United Nations definitions. It does all three of those things. Therefore, if speech falls within the IHRA working definition, it qualifies as hate speech. So why do we care? Well, free speech, you know, the university presidents and a lot of the commentators the excuses of the universities has been that, well, it's free speech. Free speech has never been free. There's always been exceptions to free speech. One example for that is defamation, in which we have many, many factual disputes that come up. Is it per se or per quad? Is it public figure or a non-public figure? Is it a statement of fact or a statement of an opinion? And for those of us who defend defamation or litigate defamation cases in Illinois, there's a unique Illinois rule that applies in some other states, but not quite as broadly, called the innocent construction rule. These are factual determinations that come up on a case-by-case basis that you don't know until you're in the middle of litigation how it's going to turn out. Of course, obscenity has, as we'll see, has never been protected by the First Amendment. And I've used two other examples based on my practice. False advertising and trademark and copyright infringement are, of course, speech. Advertising is speech. Trademark and copyright are speech. Infringement of those has never been protected. Even though they are speech, they are restricted. And of course, the last one in this list is commercial speech, which the Supreme Court, as we'll see, has held as protected, but not fully protected. So speech has always been subject to restrictions. Let's start with obscenity. It's important. In fact, there's a case coming up for oral argument in the Supreme Court in the next couple of days involving obscenity or pornography cases. What's interesting is that the case and the brief talk about speech which is indecent but not obscene. That's important because obscenity, if it reaches that level, and we'll see what that means, has never been protected. Here's Roth, the Supreme Court in 1957. It was not intended to protect every utterance, the First Amendment, and there are areas that are not within the area of constitutionally protected speech. It's not an exception. It's never been protected, and obscenity is one of those areas. They can, and this is a really important piece as we're going to come down. Obscenity convictions, and this is criminal law, not even civil, can be upheld even without proof that it will create a clear and present danger. You probably heard in the free speech context the question of imminent danger, but obscenity can be determined and convictions can be upheld even without proof that there is a clear and present danger of an antisocial conduct, or even that it will probably induce such conduct. And importantly, the Supreme Court has applied a balancing test to this kind of speech. There's no question that obscenity is speech. The question is whether it's protected speech. And determining that, the Supreme Court has held that there is a balancing test which balances the interest of the public in the quality of life against and the tone of commerce, and possibly public safety itself against the right to speech. So a balancing test, which we use in many areas of law, has specifically, expressly been applied by the Supreme Court to speech. The seminal case on obscenity is Miller versus California, also from 1973, in which the court specifically says that it has been categorically settled that obscene material is unprotected by the First Amendment. And what is obscene material? Look at the three-part test for this, and look at the standards. Again, one of the issues that we come up with in the anti-Semitism context is that it chills speech, that people won't know in advance which side of the line they fall on, and therefore we should protect it. We should err on the side of protection. Yet in the obscenity area, we don't have that line. We say that obscenity is what the average person, let's just start with that, would understand. That's a fact question. Fact questions are determined in a case-by-case basis by the trier of fact after the speech has occurred. You don't know in advance what the average person will think. Applying contemporary community standards. We don't know in advance what contemporary community standards are going to mean, and that's going to be on a case-by-case basis depending on the community. Then we have the question of whether the statute at issue, which in this case would be a criminal statute, doesn't have to be, specifically defines the conduct at issue. And then we have yet another factual determination, whether the work, remember it's speech, lacks serious literary, artistic, or political or scientific value. That's the test in Miller. Moreover, the court said that having those prerequisites, that standard is sufficient notice in advance to a dealer in such materials that he may be prosecuted, even if you don't know whether the given work falls within those three standards ahead of time. We know that the existence of the standards themselves are fair notice. And further, the court goes on to say that it may not be an easy road, free from difficulty to determine, but it expressly rejects, and it's never been overturned. This is still the law generally, as well as, of course, specifically to obscenity, an absolutist anything goes view of the First Amendment. There is no absolute right to speech. There never has been, and there certainly hasn't been since 1973. Further, and yet that the court ruled, the Supreme Court, and this is the main case, says that the First Amendment values are protected, adequately protected, because the appellate courts will conduct an independent reviews when necessary. That's exactly what's true as to hate speech. In fact, some scholars, including this one, have urged that hate speech, like obscenity, impairs the quality of life and adversely affects communities. And it has the same dangers, the same risks to society that have been used to justify unprotected status of obscenity. What we usually see in the free speech context is, starting with this case from 1969, the Brandenburg versus Ohio case. That's the one where it established the imminent lawless action test. It overturned a criminal conviction of Ku Klux Klan leader who made derogatory comments and actually threatened the possibility of violence, that there might be some revengeance taken. And the main holding, the one that is most often quoted and cited, is that the mere abstract teaching of the moral propriety or even the moral necessity to resort to violence is not itself the same and not actionable and not criminal, cannot be criminalized. The First Amendment does not prohibit or prescribe advocacy except where there's an imminent lawless action or is likely to produce that. Contrast that with what we just saw for obscenity, where there is no requirement for such proof. And the context that hate speech should be evaluated in the same way as obscenity. And yet, even Brandenburg did not stay the law. The Supreme Court has allowed free speech law to evolve over years. So 34 years after Brandenburg in Virginia versus Black, another KKK case involving cross burnings, the Supreme Court created a new test for speech that can be proscribed, criminalized in this context, and that Virginia statute prohibited cross burning with an intent to intimidate. The court declared that intent is required for criminal cases, not for civil cases, for criminal cases, and it cannot be presumed. In fact, the court upheld the statute, except for one aspect, because the statute said that doing the cross burning presumed intent. And the court said you cannot presume intent. You have to prove the mens rea or intent element for a criminal case. But it upheld the statute. And it created a doctrine called the true threats doctrine, holding that true threats are not protected speech. They never were. And so you do not have to intend to carry out the threat. You just have to make the threat. And it protects people from the fear of violence and from the disruption of their lives that fear engenders. Intimidation alone, and what we're seeing on the campuses was exactly that, is constitutionally prescribable. It is not an excuse for the universities to claim a free speech response when what was going on constitutes threats, true threats, under the doctrine in Virginia versus Black. Note, and this is an important point to be kept in mind, Virginia versus Black itself, as the language we just read, limits its ideas to the fear of violence and the fear of bodily harm or death. So what about other kinds of speech? What kinds of other threats? It wasn't considered. In Counterman, 2 terms ago, the Supreme Court then considered criminal convictions again. Now, this was not a hate speech case. Again, it was a criminal case involving social media threats against a local singer, despite attempts to block that person's access to that singer's social media. The court reversed the conviction because the trial court used a reasonable person standard, again, going back to Virginia versus Black, which said that the mens rea requirement for criminal requires something more than a reasonable standard. But in doing so, it said that a standard that would pass constitutional muster would be recklessness. I think if we talk about what was going on campus since 10/7, we will see that it almost certainly meets that standard. The case did not involve hate speech. So what did happen in the protests? Well, look at the language that was being used. I have a link to the Twitter because you can watch the video. These were, never forget, we're going to do it over and over again. Al-Qassam, you make us proud, take another soldier out. Burn Tel Aviv to the ground. We support your rockets. I'm going to ask this question. What Israeli government policy, if they were talking about free speech and such a question of public debate and public discussion of government policies, the U.S. or Israel's, what government policy do single one of these quotes? And these are what they were chanting on campus. Here's another example. You may have seen this. It's a video but I just took a screenshot of it. There's some pro-Israeli rally, and this woman is sitting next to them with a sign saying, Al-Qassam, next targets. That is a true threat. That falls within the true threat doctrine. That is not free speech. That could be prohibited and should have been prohibited on campus. And then there's another doctrine the Supreme Court has recognized, which to me applies exactly. We're talking about balancing tests in obscenity. In commercial speech, the court has also applied a four-part balancing test, a four-factor test which balances various factors. And that is, is the speech about a lawful activity or is it misleading? I would argue that what we're talking about is not necessarily a lawful activity. Does the regulation relate to a substantial government interest? How about the safety of Jews on campus? Does the regulation directly advance the asserted governmental interest? I would argue that depending on what the regulation is, it very well could be demanding that penalties be assessed for people who are intimidating others on campus and preventing access to university buildings is not free speech, and it falls within this as a factor to be considered. And is the regulation more extensive than necessary to serve that interest? People who are disrupting campus, disrupting ability to get to buildings, and intimidating other students and faculty probably fall within this four-factor test. Apply that four-factor test. To date, there has not been a case which has actually had reason to consider the issue about whether hate speech is or is not protected by the First Amendment. You may be aware of the Snyder case, a protest at a funeral of a military. That Snyder case, in fact, did not apply because the Snyders never saw the protesters, not at the funeral and not on their way to and from the funeral. They could see the top of the signs. They didn't learn about what the protesters were saying until the next night or that night on the news. The Gerber case, which was a Sixth Circuit case involving protesters in Ann Arbor near a synagogue every Shabbat, the court specifically noted that the protesters never disrupted services, never engaged with any of the people coming on. The court ducked the issue of whether there was hate speech. Also, by the way, the signs the court ruled were only involving Israel. In fact, they were about no more Holocaust movies, etc. They were about Jews, not only about Israel, and therefore they were not, contrary to what the court had to say. Unfortunately, a record was not made, I don't think, quite the way I would have hoped for. They were not talking about necessarily just Israel's and the U.S. relationship with Israel. Criminal cases suggest that hate speech can be regulated as long as there's an appropriate mens rea. And cases like Mattal, which involved a band, an Asian American band that wanted to call itself the Slants, in order to drain the negative connotations of that word, and the trademark office refused to grant that trademark. The Supreme Court ruled they could, but nobody was claiming that the word was derogatory. In fact, that if anything, the band Mattal was trying to change that to be non-derogatory. And a case that's often cited is the Claiborne case, which was a boycott of white merchants, and it's often cited in the context of whether boycott BDS is and anti-BDS laws are constitutional or not. But the plaintiffs in that case were the white merchants. In fact, in Claiborne, there were many Black members of the community who were targeted by the NAACP and the protesters in that case. If they went into a white business, they were literally threatened, and there were people who were shot, and there were people whose vehicles and houses were vandalized because they happened to patronize a white merchant. Imagine if those people who were intimidated by the boycott were the ones who were the plaintiffs in the case. We might have had a different answer. Ilonis is a Supreme Court case involving a criminal case, and it suggests that in a civil case, because that's another one where they use the negligence standard for a reasonable person standard for criminal, that in a civil case, the reasonable person standard would be perfectly fine to use. And in Hudson, again, we have the four-part test. So free speech can be chilled. And now that we cut the question of chilling speech. In fact, in Counterman, the one we just talked about, the court raises a concern about chilling speech, that a speaker may be unsure about which side of the line they fall on. And yet, the court talks about defamation as an example that the court had ruled had no constitutional value, and yet the example they use is of a public figure where they have to show the actual malice standard. Except most cases of defamation are not against public figures, and a negligence standard applies. And even if you apply the scienter requirement, it still chills speech. You don't know whether it's going to be considered intentional or reckless at the time you necessarily give it. So I would argue that if the right plaintiffs had been there, the Snyder and Gerber case could have met the recklessness standard if they given the particular facts of the cases, if the plaintiffs had seen the speeches or were otherwise affected. So chilling speech is allowed under the law. After all, the entire point of defamation and other areas of law is to chill speech, to prevent defamation from occurring, to ban or bar obscenity, to prevent infringement. That's why you have those consequences, is to chill people from doing those speech and that conduct. They create consequences for those who engage in speech that has no constitutional value. And I didn't say that word. That's from the Supreme Court who says that, and discourage people from engaging it. Hate speech has similarly been held to have no constitutional value, and there's no reason why we shouldn't be able to chill it. So the court has rejected an absolutist application of the First Amendment. It is not an excuse for the universities, not a legitimate one. The court has applied balancing tests and restricted speech, and that should have been applied to the various campus situations. And if it comes up, again, that can come up if they use it as a defense. Hate speech is not protected by the First Amendment, and no court has ever so held. Criminal prosecution can be proper if there's at least recklessness. Civil liability is available under tort law. Falling within the IHI working definition likely qualifies as unprotected hate speech, and the true threat doctrine, as we've seen, applies to much of the speech that we saw on campus since 10/7. We might still have further evolution of the law. Robert, you're
Thank
muted.
you, David. That was an engaging presentation and some novel ideas. For the presentation, obviously, I thank you, and for everything you do to fight anti-Semitism and stand up for the Jewish people, I also thank you. Eliza D. Lewin, our next speaker, received her BA from Princeton University, her JD from New York University's School of Law, and began her law career in Israel, where she clerked on the Supreme Court for Deputy President Justice Menachem Alon. Ms. Lewin is also a co-founder and partner with her father in Lewin & Lewin LLP, where she has specialized in litigation, mediation, and government relations. Her experience includes criminal defense, civil litigation, and anti-discrimination matters. She is a past president of the American Association of Jewish Lawyers and Jurists, and currently served as president of the Louis D. Brandeis Center for Human Rights Under the Law, a nonprofit organization established to advance the civil and human rights of the Jewish people, promote justice for all, and which combats racism and anti-Semitism on campus. Ms. Lewin led the litigation team that represented Avi Zinger, the Israeli licensee of Ben & Jerry's ice cream, in the lawsuit that Mr. Zinger filed against Unilever to prevent Ben & Jerry's boycott of Israel. Ms. Lewin negotiated a successful resolution to that matter, pursuant to which Avi Zinger obtained the right in perpetuity to sell Ben & Jerry's ice cream everywhere in Israel and in the territories using the Hebrew and Arabic logos. In 2014, Eliza Lewin argued Zivotofsky versus Kerry, the Jerusalem passport case, before the U.S. Supreme Court, a case involving the constitutionality of a law granting any American citizen born in Jerusalem the right to list Israel as the place of birth on their U.S. passport. In Zivotofsky, the Supreme Court held that the President of the United States has the exclusive authority to recognize foreign sovereigns. The case paved the way, however, for President Trump's recognition of Jerusalem as the capital of Israel and recognition of Israel's sovereignty over the Golan Heights. After 18 years, Ms. Lewin brought this pro bono case to a successful resolution in October 2020, when Secretary of State Pompeo revised the U.S. passport regulations and Ambassador David Friedman presented her client with the very first U.S. passport to list Israel as the place of birth for a U.S. citizen born in Jerusalem. Please join me in welcoming Eliza Lewin as she addresses the topic of old trends, new developments. Eliza, it's yours.
Thank you very much, Robert. Thank you to the Decalogue for putting this whole program together. It's really a pleasure to be here. I'm I don't know if I've been spotlighted or you're still spotlighted because I'm still looking at you on my screen, but that was good.
Sorry, but it's really a pleasure having you here too. Thank you.
Excellent. So I think in a way to try and tie together what we've heard now from both Steve and David, I would like to suggest that one of the ongoing challenges where we've seen now some new developments has been the challenge of getting society to actually recognize the difference between what is a good faith political debate about the Arab-Israeli conflict versus what is really the vilification and the dehumanization and the demonization of Jews. And okay, I've just shifted my view so I can actually see the rest of you because all I was looking at before was Robert for some reason. And so if I can step back for a minute to talk about Title VI. So Title VI of the Civil Rights Act of 1964, it's not quite accurate, as Steve said. In terms of 2019, there was a significant development, but it has actually been the last 20 years, since 2004, that there has been an understanding that Title VI of the Civil Rights Act covers Jews, Sikhs, Muslims, members of faith-based communities, even though Title VI of the Civil Rights Act does not include religion as a protected category. And the reason for that is that back in September 2004, when Ken Marcus, who later went on to found the Brandeis Center, the organization that I now run, that he was then the acting assistant secretary for civil rights in the Department of Education, and in that position oversaw the Office for Civil Rights. And as Steve correctly said, is that you have a choice. When there's a potential violation of Title VI, you can either file an administrative complaint with the agency that has given out the money, because what Title VI basically says is if you're getting federal funding, that money comes with strings attached. And the strings are that you have to make sure that all the opportunities you provide are provided in a non-discriminatory fashion. If they're not, if there is a student or students at a school, for example, or some individual or individuals who are being denied equal access to the opportunities that your entity provides, that could potentially be a violation of Title VI. And so one way to go about pursuing your rights is to file an administrative complaint with the agency that has provided the funding. The other would be to go and file a federal case in court, hire a lawyer and pursue that avenue. What happened after 9/11 is that there were actually members of faith-based groups who were experiencing discrimination, particularly in the education space. You had Muslims who were being harassed after 9/11, and then you had Sikhs who were suffering horrible bullying in the schools because people mistakenly thought that they were Muslim. And so these individuals started to file the complaints with the Department of Education, and the initial attitude was, well, that's religious discrimination and we don't cover that. And Ken was at the department at that point and said, no, wait a minute. If you have members of faith-based groups, they don't lose if they're being targeted on the basis of one of the other categories, race, color, national origin, that Title VI provides. They don't lose that protection just because they also share a common faith. And he set out this understanding in what's called a Dear Colleague letter, which is how the agency set out their guidance. So there is a 2004 Department of Education Dear Colleague letter that Ken issued, which was the first to set out this understanding that even though Title VI doesn't mention religion, members of faith-based groups are covered when they're targeted on the basis of their ethnic characteristics, their shared ancestry. That was in the Bush administration. Every successive administration has followed that understanding since then. So in 2010, in the Obama administration, the Department of Justice issued its own Dear Colleague letter, and I quote one small piece from that letter said, quote, although Title VI does not prohibit discrimination on the basis of religion, discrimination against Jews, Muslims, Sikhs, and members of other religious groups violates Title VI when that discrimination is based on the group's actual or perceived shared ancestry or ethnic characteristics rather than its members' religious practice. So in 2010, they set out, and this is still followed till today, the idea that Title VI will cover members of faith-based groups when they're targeted on the basis of their shared ancestry or ethnicity, as opposed to their religious beliefs or their religious practice. Religious beliefs, religious practice is still a small area that Title VI may not cover, but if you're targeting Jews, Sikhs, Muslims on the basis of their ancestral heritage, right, then that would be covered by Title VI. What happened in 2019, which is what Steve is referring to, is the Executive Order 13899, the Executive Order on Combating Anti-Semitism. That was the executive order that was issued by President Trump and mischaracterized widely in the press and in the media as suddenly adding Jews to the equation. That's not what it did. What the executive order did is it married this understanding of Title VI with a definition of anti-Semitism. Now, 2010 was actually, if we go back for a minute to 2010, a big year, because in 2010, not only did the Department of Justice issue its this letter about how Title VI covers members of faith-based communities, but the Department of Education in 2010 followed up with their own Dear Colleague letter, the long letter that talked about what are schools supposed to do then if they find that a hostile environment's been created on this basis. And they set out there, again, a requirement for the schools that what the schools are supposed to do is they're supposed to take prompt and effective steps to, one, end the harassment, two, address the hostile environment, and three, prevent the harassment from reoccurring. That, till today, is still the standard. It was set out in 2010. 2010 is also the year that was the first time that the United States adopted a definition of anti-Semitism. The IHRA, the International Holocaust Remembrance Alliance definition of anti-Semitism, was not issued until 2016, 6 years later. But in 2010, the US State Department adopted a definition of anti-Semitism. And in some of the materials that I gave to Robert to distribute, you'll find links to both the 2010 State Department definition and the International Holocaust Remembrance Alliance definition of anti-Semitism. And I recommend reading both of them side by side, because what you'll find is that they are almost word for word identical. They both start with a definition of anti-Semitism at the top, followed by a list of examples. The main difference between the two is that the 2010 definition pulled out the examples relative to Israel, put it on a separate page, on the second page of the definition, under a big heading that says, what is anti-Semitism relative to Israel? Now, mind you, that's 2010. They're putting this together. That's still the question we're grappling with today. What is anti-Semitism relative to Israel? And what they do is they put the examples, they divide them into three categories with three subheadings. One is demonize Israel. The next is double standard for Israel, and the last is delegitimize Israel. Some of you may recognize those as what have been called or referred to as Natan Sharansky's 3Ds. In the early 2000s, Natan Sharansky came up with an idea of how to try to distinguish when does the criticism of Israel cross the line into anti-Semitism. In other words, the question that we started with, how do you tell the difference between a legitimate, good faith political debate about the Arab-Israeli conflict or Israel's policies and the vilification of Jews, which is the anti-Semitism? And the answer is, does it demonize, does it apply a double standard, or delegitimize Israel? So demonize, and you can read these examples, but demonize would be if you imagine the kind of typical anti-Semitic caricature of the hook-nosed Jew that is bloodthirsty and conniving and greedy. But the idea is that you take that demonization, and instead of applying it to individual Jews, you're applying it now to Israel as the Jewish collective. So Israel is the collective Jew. That's not a criticism of a specific policy or a good faith debate. That is equating the Jew with evil, with the demon, with the devil. And now instead, you're just doing that with Israel as the collective Jew. The double standard would be what you see at the UN, for example, where you're holding Israel to a higher standard than any other country. You have more resolutions condemning Israel than against all the other countries combined, including Iran and Russia and China and North Korea and any of them, that would be the double standard. Delegitimizing Israel is interesting because that becomes the issue that we see a lot on campuses today. Delegitimize Israel, in the 2010 definition, it says, the example is denying the Jewish people their right to self-determination and denying Israel the right to exist. It's slightly different in the IRA definition. In the IRA definition, the example says denying the Jewish people their right to self-determination, e.g. by claiming that the existence of a state of Israel is a racist endeavor. But here's where I think that one of our biggest challenges has been that not only do people not understand anti-Semitism, they don't understand Jewish identity. And there has traditionally been this sense, and one of the new developments, and I'll talk about this in a minute, is this insistence that Jews are only a faith, that we're only a religion, and the denial and erasure of the idea that Jews are also a people, and that there are many Jews who do not define their Jewish identity according to religious practice or religious belief, but who say, I define my identity as part of a people. And that means to me that my people have a history, they have a heritage, I have an ancestry. I mark Passover because I believe that my ancestors were liberated from slavery in Egypt. I just marked Hanukkah because I believe my ancestors were the Maccabees. It's not possible to separate the Jewish people's history and heritage from the land of Israel. That's where our identity as a people was forged and cemented. And yet there is a growing effort today to actually erase and deny that the Jews are a people, and that we have any history connected to the land of Israel. In fact, I will tell you that just last semester at Boston University, Students for Justice in Palestine published this brochure filled with all sorts of language that is problematic. But here's one quote in particular, which says, quote, and this is again, SJP, Students for Justice in Palestine at Boston University, says, quote, we do not accept the term, quote, Jewish people, close quote, in any form whatsoever. And then it goes on. For us, there is only one Jew. Like all Jews know, there's only one God, and that is a religious Jew, close quote. And so when you come back to this delegitimizing Israel, if you say that you are denying the Jewish people their right to self-determination, what you really are doing is saying, you know why you have no right to self-determination? Because you're not a people and you're not indigenous to that land. That's what denying the Jewish people the right to self-determination, that's what suggesting Israel has no right to exist is really about today. It's really about saying, you Jews, you have no right to a state here. You're just a religion. You're just a faith. And in fact, the narrative now today, when you talk about new developments, that we see underlying everything. It's the courses on campus. It's the ethnic studies classes in California and across the country. The narrative is one that says, everything that ever happened in the Holy Land since creation is Palestinian. Yes, there were Jews, there were Christians, there were Muslims in this land, but those are just religious, faith-based identities. This narrative says that the cultural, ethnic identity of every individual who ever lived in this land was Palestinian. That's how you get this idea that Jesus was a Palestinian. And then they say, we know the difference between the Jew and the Zionist. The Jew, they say, is the one that accepts that Jews are just a faith and a religion. The Zionists they accuse of being the one who they claim is erasing Palestinian history and heritage by calling it Jewish. And now today we've seen a term that in Canada they've actually tried to get ensconced into law called anti-Palestinian racism, which they are defining so broadly as to encompass anything that pushes back against this narrative that I just described for you. Meaning that if you have a Jew who says, I define my identity as part of a people indigenous to the land of Israel, that now is called racist, because somehow by claiming Jewish identity as a people, that is now accused of erasing and denying Palestinian history and heritage, because Jews, you should understand, they claim, are not a people and have no history in the land of Israel. So coming back to this definition of delegitimize Israel, denying the Jewish people their right to self-determination, that's not a good faith political debate about the Arab-Israeli conflict. That's erasing and denying and demanding that Jews shed an integral part of how they define their identity as Jews. Now, just one other quick bit about the Office for Civil Rights and an example of what the executive order meant in practical terms. So the executive order turned around and said, if you're one of these agencies that gives out money and you are faced with a complaint that alleges anti-Semitic harassment and discrimination, how are you supposed to understand what anti-Semitism is? What the executive order said is you refer to the IRA definition of anti-Semitism, and only the IRA definition of anti-Semitism. That too, the executive order, is also still in effect and has been followed by the Biden administration. Not only is there guidance on the website, frequently asked questions about the executive order, but repeatedly over the years, every time the Biden administration would send out, and this is even before October 7th, when they issued, for example, the national strategy, and they sent out a list of resources to all the universities, this frequently asked questions about the executive order was on that list of resources. And what does it mean then for the Department of Education to apply the executive order and use the IRA definition? Well, we filed at the Brandeis Center, for example, a complaint against the University of Vermont, and this predates October 7th, because what we're dealing with started way before October 7th. So at University of Vermont, the anti-Semitism there was overwhelmingly the anti-Zionist form of harassment and discrimination. So for example, you had a sexual assault survivor club, the biggest group on campus. We're talking thousands of students. After the last Gaza conflict in 2021, this club announced that they were blocking Zionists. And when Jewish students tried to reach out, I mean, this is the biggest support group on campus, and they wanted to have a conversation, they said, we don't talk to Zionists. There was a book club called the Revolutionary Socialist Union Book Club at UVM that advertised on a website that had different book clubs from the university. And to be a member of this book club, you had to pledge no to a long list of things that included racism and Islamophobia and homophobia. And you had to pledge no to anti-Semitism, but you also had to pledge no to Zionism to be a part of this club. And then there was a teaching assistant, and this teaching assistant thrilled to harassing Zionists online. She even posted about the serotonin rush she got to bullying, cyberbullying the Zionists in the public domain. When there was someone who had stolen an Israeli flag from outside a residence where Jewish students lived and no one knew who did it, she posted on social media commending that person, calling them the Spider-Man of Burlington, anonymously doing good. And then she had this tweet where she said, "Is it unethical for me, a TA," she was a teaching assistant, "to deny participation credit to Zionists? I think it would be good and funny," she writes, -5 points for going on Birthright in 2018, -10 points for posting a pic of yourself with a tank in the Golan Heights, or -2 points just because I hate your vibe in general. And what happened is we filed this complaint with the Department of Education. These complaints, as Steve said, are usually what happens is the universities, they don't want to lose the government funding. So what they do is they negotiate what's called a resolution agreement and ask the Department of Education, what do we have to do? What steps do we have to take in order to continue getting our money? And at that point, the Department of Education said, look, you're going to have to change your policies, you'll have to change your training, among other things, in order to address this kind of harassment and discrimination, which they referred to as a form of national origin discrimination on the basis of shared ancestry. So if you're talking about trying to apply Title VI to Jews, what we have now established with the Office for Civil Rights and with the Department of Education is that when Jews are targeted on the basis of our shared ancestral and ethnic heritage that links us to the land of Israel, that is covered by Title VI of the Civil Rights Act of 1964. And yes, now after October 7th, 2023, there have been many more cases also filed in the federal courts, because the fact patterns are much more egregious, But the challenge now is to get the courts to also understand this notion of Jews being targeted on the basis of our shared ancestry and ethnicity. And I'll just give one final, because I think it's interesting to understand some of the differences that go into considering whether or not to bring this as an OCR complaint or to bring it in federal court. So one, as Steve mentioned, is the need in federal court for a named plaintiff. Before OCR or any of the administrative agencies, certainly the Department of Education, you do not have to be the individual who experienced the harassment to file the complaint. Anybody can file a complaint. So we've seen after October 7th, you had newspaper editors who filed complaints, organizations who filed complaints. It doesn't have to be the students, so the students can remain anonymous. There's also a much tighter statute of limitations when it comes to the Office for Civil Rights. There's a 180-day statute of limitations to file a complaint with the Office for Civil Rights, much longer when it comes to filing a lawsuit. The other thing is that if a student has actually requested that the school investigate the matter, the Department of Education will not then investigate the same set of facts. One of the ways they can try to keep their docket clear is they say if somebody else is investigating or dealing with the same set of facts, and you ask us, we're not going to deal with it. So if a student has asked the university to investigate, OCR won't investigate. The most they will do is say, well, was there an actual process? If there was, great. They won't even second guess the outcome. So the sad thing is that sometimes schools will use this process. Nothing will come of the investigation, in part because they don't understand anti-Semitism or Jewish identity and that we're more than just a faith. And so then they may not be able to go to OCR and they may have to bring a lawsuit. And the other significant distinction is, as Steve was saying, the issue with deliberate indifference. The standard with OCR is this prompt and effective, that they have to take prompt and effective steps to, as we said, end the harassment, address the hostile environment, and prevent the harassment from reoccurring. Whereas in court, you need to meet this deliberate indifference standard. And that is a challenge because, it's not yet clear exactly how much schools have to do to meet that standard. And of course, they're all saying, well, we uttered the right words. It's not our fault if it didn't make anti-Semitism go away, but you can't say we were deliberately indifferent. So it's a greater challenge. And when you have situations where the schools have actually taken some steps, but maybe not enough steps, it is a challenge to bring those in federal court. I guess we want to leave some time for questions. I would just say one final thing also about the IHRA definition, because again, the IHRA definition in and of itself does not prohibit or silence or punish anything. As a matter of fact, both in the 2010 definition and in the IHRA definition, you have the sentence that says, criticism of Israel similar to that leveled against any other country cannot be considered anti-Semitic. So it is certainly not designed to silence criticism of Israel. It's not even designed to label the criticism of Israel as anti-Semitism. What it's trying to do, though, is help folks who use it to understand where that line is so that we can label as anti-Semitism what is the vilification of Jews as opposed to that good faith political debate, and then use that to understand anti-Semitic, when conduct is motivated by anti-Semitic bias, and to recognize, right? Because you can say in this country, and we want to talk about the First Amendment, you can say some very racist things. You can say some anti-Semitic things. You may not be able to act, right? In the pursuant to your anti-Semitic beliefs and discriminate or intimidate or threaten, right? But you can say those things. And the other thing is the First Amendment, while it might not prohibit you from saying racist or anti-Semitic things, it also doesn't protect you from being labeled the racist or the anti-Semite if you do. And what we see from so many of the people who are opposed to the IHRA definition is that what they really want is they don't want to be labeled. They want to be able to engage in conduct that is anti-Semitic without being labeled as Jew haters. So they're trying to create a big gaping hole through which they can drive their semi-tractor truck through, filled with anti-Semitic hate without it being considered anti-Semitism. And that's one of the things that the IHRA definition is designed to try and address.
Thank you, Eliza, for a wonderful presentation and for all that you do to protect Jewish students and help the Jewish people in the state of Israel. And I really appreciate your participation as well as the participation of Steve Blonder and David Levitt tonight. I also want to remind people who came late that this program, that I'm the president of the Decalogue Foundation and a past president of the Decalogue Society of Lawyers. This is a Jewish Bar Association founded in Chicago in 1934. And we are supporting and presenting this program along with co-sponsorship by the American Association of Jewish Lawyers and Jurists, the Louis D. Brandeis Center, Stand With Us, and DePaul University College of Law Center for Jewish Law and Judaic Studies. We encourage everyone here to support each of these organizations so that we can continue to provide legal and educational programming, support the law and Jewish students, and stand with the state of Israel. I also want to take a few seconds to thank Aviva Pat, the executive director of the Decalogue Society, for everything she did to organize and make sure the logistics worked out right and disseminate material, et cetera, et cetera, et cetera. For everybody who's looking for their MCLA credits, please make sure that you stay on until the end, where we will have a survey posted for feedback so that you'll be able to get the credits, and then the CLE certificates will be emailed in the next few weeks. Also, the program is being recorded and will be posted to the Decalogue Society's YouTube channel very soon, I'm sure. That way, Eliza can make sure her father watches it and gets nachas. And Steve will do the same for his mother. I'm David. I don't know your family, but I'm sure you'll have some loved ones who will get a lot of nachas from your participation too. At this point, I'm going to be opening up that chat box because I know there's a lot of questions that have been posed. First question, and I'll just do them in order of how they presented them, is from Judge Michael Jordan. Will it help in future litigation that one of the last acts of the Biden administration was to recognize being Jewish as a protected minority? I believe it was issued by the Commerce Department last week.
As I was saying, I don't think that that's something new, right? In other words, it's been 20 years now that Bush administration, Obama administration, Trump administration, Biden administration have all recognized that members of faith-based groups are protected by Title VI. They're clearly protected, in Title VII when you include religion. The issue is whether Title VI, that didn't include religion as a protected category, extended to these members of faith-based groups, and that's not something that's new. What did happen, what the Biden administration announced months ago, was that they were extending this understanding of Title VI to 8 additional, not just the Department of Education, but to 8 additional cabinet agencies.
Thank you. Steve, I'm going to put this question to you. Why can't the parents be the named party in the litigation? Because they're the ones paying the tuition in most cases. And if that's the case for their child, and if the child is not being allowed to fully use the university, especially if it's a public university.
So the parent doesn't have standing. Once the child is 18, they're the age of majority, the child needs to step up for themselves. There's limited circumstances where you can make a claim for organizational standing, but the law has been kind of moving on that. Seventh Circuit in particular is not great on organizational standing. But the parents, they didn't actually suffer the injury. They're not the one being deprived of the educational opportunity. They're not being deprived of the access to campus. It's not about who's paying the bills. It's about who's getting an education. Thank
you. A question asking people to sign the University of Illinois Board of Trustees, to sign the petition asking the University of Illinois Board of Trustees to extend the Memorandum of Understanding protecting Jewish students at UIUC to the rest of the university ahead of their January 23rd meeting was posted by Gail Eisenberg in the chat. If anybody has seen that or wants to sign, please do. We have a question for anti-Semitism occurring to employees, not students, of Chicago area schools. What agencies do you recommend to file complaints for investigations? David Fish has found that the EEOC is ineffective and would imagine the Illinois Department of Human Rights or Chicago Cook County would not be useful.
Right, I'll take it, Bobby. You know, in terms of local, unfortunately, they may not be helpful, they may not be useful, but those are where you have to go. Unfortunately, just like on campuses, we talk about how the DEI offices often don't have anti-Semitism training. They don't understand what it is. They don't understand the anti-Israel concepts. The same would be true, most likely, in the federal and state agencies and local and city agencies charged with enforcing the anti-discrimination laws. But that's got to be the first place to go. In a similar vein, there's some that suggested an OSHA related complaint relating to employment, and the same issue is going to be there. You've got OSHA investigators and OSHA inspectors who just aren't attuned to the real issue, and it runs a risk of creating bad law.
How has deliberate indifference been defined in the context of Title VI and litigation in the area of anti-Semitism litigation?
I mean, it's kind of one of those, you know it when you see it. It's like the old Potter Stewart phrase in terms of pornography. As Eliza referenced, there's not the specific definition of it per se to use. It's kind of a fact-based inquiry. And it's kind of, we're going to learn as case law develops, what situations and where was the response sufficient, where was it not. Unfortunately, there's no guidance yet in terms of a bright line that you can look at and say, aha, this is where you have it, or this is where you don't.
I'm going to give one to, this is coming from Professor Steve Resnikoff, the director of the DePaul University College of Law Center. So I'm going to let David Levitt take this one here. The language regarding the repetition of October 7, about how many times they would commit the atrocities, does not seem to be a threat to those in the U.S. Has any case held that such a threat made in the U.S. would be a, quote, true threat, close quote, that would be criminally actionable in the U.S.?
No, but I would argue that if you looked at some of the video on the one that's on Twitter, that was at Columbia University, and that person was yelling at Jewish students at Columbia, telling them that it wasn't just going to be the Jews in Israel who were going to be attacked, it was going to be Jews in the United States too. Steve's next question is about globalizing the Intifada. That's the same thing. They're threatening Jews around the world, including those who are near them on campus. They're trying to intimidate them from their own free speech and from their own living, as going back to Eliza's, living their own Jewish identities and recognizing them. That is intimidation, and in this case, that's a threat of violence. Both the Intifada talk and the we're going to do 10-7 over and over again. They're not just talking about going over there and doing it. They're talking about doing it here, and they're saying it to students on campus, on their campus, right then and there.
David, do you think that there could be a class action for that type of speech by a class of people who felt intimidated?
Yes, there could be, I would think. People similarly situated. Of course, you have to figure out who you're going to sue first, right? Because the question that we're talking about is who you're going to sue the people who said it. You're going to sue the SJP. You're going to sue the organizer of the event. But what we're here talking about now is the university using the First Amendment as an excuse. And in fact, it's not an excuse, which is the larger point. If the university refused to act, I would argue, although I will defer to Eliza and Steve with their greater knowledge of deliberate indifference in Title VI, that it is evidence of their refusal of using a false free First Amendment argument that is evidence of deliberate indifference, because those people had no idea what the First Amendment actually did or didn't protect. They didn't do a reasonable investigation about it. And that would be evidence to me of potentially deliberate indifference in terms of a class. Now, the question that asked about group libel as well, there is a U.S. Supreme Court case, I get the first name mixed up, Burnhouse versus Illinois, which recognized group libel. It was a long, long time ago. It's never been followed very much. Most scholars talk about that case, have said that it's been eroded by the court and no longer is a valid doctrine, but nobody's actually ever said that. It's never been officially overruled. And there is an argument to be made that group libel against any group, but against Jews in the context of anti-Semitism, does potentially state an actionable claim, although it would be an uphill battle since it hasn't been followed for a long, long time.
Elisa, one of the participants said that they're aware of an OCR case that's been awaiting action for over 4 years. Can anything be done to force OCR, the Office of Civil Rights, to move any faster? And I know the UIUC case was pending for even longer than that.
Yeah, the UIUC case took about 4 years, at least 4 years. Unfortunately, you can't really force their hand. What you can do is, if you brought the case or you're one of the people, you can try to reach out to the investigators to, update them on new information, just try and make sure that it stays on their, on their radar, that they're involved, they're engaged, but there's no way to, unfortunately, speed up that process. One of the things that OCR has been offering now is that if you request at the same time that you file the complaint, if you request mediation, then even before the investigation starts, if the university agrees, then they'll actually permit you to mediate. And we've done that in several cases, which has at least brought us much sooner into direct communications with the administrators. And in, for example, our Occidental case, we negotiated a settlement with Occidental because of that. And that was helpful. So that's one of the things that OCR does provide, I think, in part because they realize that some of these cases are dragging out. I would just say one of the things in terms of new developments is there are, as Steve mentioned, language that we had, for instance, from the UIUC decision, where, among other things, UIUC reinserted in the settlement agreement language from a joint statement on anti-Semitism that JUF and the community had negotiated when we first started this, which said, and I'll just give you a little quote here, "For many Jewish students, Zionism is an integral part of their identity and their ethnic and ancestral heritage. These students have the right to openly express identification with Israel. The university will safeguard the abilities of these students as well as all students to participate in university-sponsored activities free from discrimination and harassment." And we saw, as Steve also mentioned, NYU came up with some, also in a settlement, very good language about that they explained how their policies would be applied to cover the use of Zionist or Zionism. And so their language says, quote, "Using code words like Zionist does not eliminate the possibility that your speech violates," this is the NYU policy, "for many Jewish people, Zionism is a part of their Jewish identity. Speech and conduct would violate the NYU policy of targeting Jewish or Israeli people can also violate the NYU policy if directed towards Zionists. For example, excluding Zionists from an open event, calling for the death of Zionists, applying a quote-unquote no Zionist litmus test for participation in any NYU activity, using or disseminating tropes, stereotypes, and conspiracies about Zionists, e.g., quote, Zionists control the media, close quote, demanding a person who is or is perceived to be Jewish or Israeli to state a position on Israel or Zionism, minimizing or denying the Holocaust or invoking Holocaust imagery or symbols to harass or discriminate." So we're very slowly starting to see some of these schools begin to recognize this form of harassment against Jews and include it and incorporate it in their policies. Now, of course, the question is going to be, will they continue to enforce that? But we are seeing real change at UIUC and also in certain cases at NYU.
Right, Elise, I always want to add one thing to that. One of the things to watch at Northwestern in particular, I think it was in November, a lawsuit was actually filed against them on Title VI claims and some other claims by a Palestinian student, alleging that the school is discriminating, violating Title VI vis-a-vis the treatment of Palestinian students. That's the first of those cases that's been filed against a major university. And the question is going to be how that plays out in the campus discussions, campus debates, in terms of adopting definitions that Elisa was referencing, in terms of that's going to be a new battlefield as well.
Correct.
Absolutely. I'm cognizant of everybody's time. We've run for an hour and a half. I'm not chasing anybody off the screen, and we're going to post the evaluation. Please stick around, and at some point in the very near future, I'll ask Aviva to unmute people if they want to have a conversation. But while we're posting that, one thing I'm going to ask the panelists, there's a lot of good pro bono work that's being done, but some of it has opportunities to earn fees when you're successful. Steve, Elisa, do you want to talk about that possibility? Because that might be something that would encourage other lawyers to spend some of their time also.
Sure. Some of the statutes, the civil rights statutes are in fact fee shifting, and you can seek fees from it. And obviously to the extent that's something that people are choosing to do that's out there, I would be careful though, kind of if you're going to proceed along those lines, simply because look, a lot of what's happening, the law is kind of shifting and changing. It's not well developed in these areas right now. And there's a lot of coordination and things happening behind the scenes in terms of lawyers who are involved in this. And one of the concerns that there is when we talk about new claims is creating bad law in different places, different circuits, different courts. And so kind of the lawsuits that are being filed are being carefully thought through and vetted and kind of analyzed in terms of, okay, what's going to be the potential unintended consequences of bringing a suit in that particular location, in terms of the law in this area generally.
I think that's very good advice to keep the ambulance chasers out of the field. If anybody is experiencing or knows anybody who's experiencing it, call Eliza Lewin or Steve Blonder. And if you can't get a hold of them, get a hold of me. Aviva, do you want to unmute? I want to thank everybody who's participating. We have participants from coast to coast, from Washington, D.C. and New York and up in Vermont and California and Oregon and Texas and Florida and Georgia and obviously here in Chicago, where we're headquartered. But I think that this is something fantastic that I hope that will be posted sooner than later on the Decalogue Society YouTube channel, because I know we did a program that was it went viral within a matter of a few weeks when we had over 100 participants live, but within a month we had over 700 views of the recording. And this is information that should be disseminated and shared as soon as possible. Sorry for the pressure, Aviva. Aviva, you can unmute everybody if you'd like to. How's
The questionnaire keeps disappearing.
Okay, for the panelists, don't touch the questionnaire.